This is a unique motion for continuance. There is presently a final hearing set next week, October 9th. It is a final hearing. And so to give the court some background, the parties were married on March 6th of 2024. So it is a 19-month marriage. The parties have two children that were born before the marriage, Flora, who is 3, and Skylar, who is 2 months shy of 2. So two daughters under the age of 2. This petition was filed by Mr. Thompson on July 21st of 2025. So it's been pending for 72 days, just 12 days over that 60-day mark. At the beginning of the case, Ms. De Silva Thompson was representing herself. She retained me, and I filed my original answer and counter petition on August 26th. That day, I also filed my motion for continuance, knowing that the final hearing was set on October 9th. On September 12th, I sent discovery to Mr. Thompson, and they responded last week on September 29th. And I'll put a pin in that and discuss that with the court here in a moment. Then on September 12th, they served discovery on us. So technically, our discovery wouldn't be due until after the final hearing. So although there is a request to have a final hearing on October 9th, discovery was propounded on us with the anticipation that that discovery would not be answered, I guess. We also, in our original petition, requested temporary orders, and Mr. Thompson, in his original petition, also requested temporary orders. And then in this most recent amended petition filed by Mr. Thompson on September 25th, maintained that request for temporary orders. All that, I'm saying all of that because I originally said this is a kind of a unique motion for continuance. The final hearing is set on October 29th, and we are requesting, I'm sorry, I misspoke, on October 9th, and we are requesting that that hearing be a temporary orders hearing. I think the concern is, when are we going to have a final hearing? And I've been clear with Mr. Russell that we're amenable to having a final hearing in December. Now, one thing, and I think it's kind of ironic given that the previous case that the court had, my client is a Brazilian national. She is here on a K-1 visa, and she does not speak English. This is ultimately for her a request to be able to move back to Brazil. Any evidentiary hearing is going to require an interpreter. And as this court knows, with interpretation, there is a lot of back and forth. I do not believe it would be a service to Ms. De Silva Thompson to have a truncated 3-hour final hearing crammed down next week rather than a long docket hearing. And I don't think for the court that would be efficient either. I've previously tried hearings where I require a Spanish interpreter, and even Zoom or in person, there requires a lot of back and forth. So we are asking that this be on a long docket setting. And in addition to that, in Mr. Thompson's request, Mr. Thompson is requesting that he be a sole managing conservator. So to try a case where one party is asking one extreme and the party is also asking for another extreme in 3 hours with an interpreter, I think it is just not feasible. But I said I would put a pin in the discovery issue Um, I reviewed very briefly their discovery, and although we requested documents going all the way back to date of marriage, I have received one bank statement for every bank account. I do not have a picture and a full picture of where the money is being spent. And for my client cannot work here. I think there will be discussion about whether or not she can make an income in Brazil. But my client is the full-time caregiver for the girls. My client lives in Spicewood. She does not live in downtown Austin. It's isolated. She does not speak the language, uh, and she is solely dependent on Mr. Thompson financially. Not only that, Mr. Thompson depends highly on her because the girls are not in any form of daycare at Mr. Thompson's by Mr. Thompson's choice. So she is out in Spicewood, isolated, financially dependent on him. Mr. Thompson is presently employed by Amazon and travels very frequently. So we are requesting that next week, for all of those reasons, be a temporary orders hearing, and that the final, if I think everybody will agree that we'd like this case to get wrapped up, and I'm offering that, that the final be in December. And specifically, I have discussed with Mr. Russell the final hearing being December 15th. That's all I have.
Okay. All right, Mr. Russell.
And the reason I'm just going to kind of go into the reason we're contesting this, the real problem here is, and I think nobody disagrees with the fact, the question for this court is whether or not Mrs. Thompson can move back to Brazil. She is not going to stay here. I think that's very clear from what they already, what opposing counsel has already stated. It's very clear that my client has been told that multiple times by Mrs. Thompson, and that's the question. And so by having, we think it's a waste to have a temporary orders hearing when we know the point is, the question that needs to be asked is, can she move back with the kids to Brazil? That's the argument that we're having. So to have a temporary orders hearing, in our opinion, is just a waste of time. We're pushing off the unavoidable situation. Is she going to be allowed to move with the kids, or are the kids going to stay here in the United States? So we're asking the court to either order for the final hearing in October, or to have it be upon the agreed date that we discussed. I believe it was on Monday in December. That be the final hearing date, with the understanding that we may need some more time because of the translation. But our point is, there's no need for a temporary orders hearing. There just needs to be a decision on whether or not they can move back, whether or not the kids are staying here in the United States or the kids are going to Brazil. So it just doesn't think it makes a lot of sense to have a temporary orders hearing in that situation. We need to that decision about whether or not the child can, or the children are going to Brazil or they're staying here, that needs to be made quickly. Otherwise, we're going to be in a very awkward, I think, situation for the next, couple months. So I think it really presents a unique situation because something needs to be decided. Hey, can she move or not? I mean, and I think the property stuff probably is going to be, and we could probably mediate that portion of it. It's just that's the question that's before the court, and that question needs to happen sooner rather than later.
Okay. Is there any reason why you wouldn't mediate the entire case?
Well, the parties cannot agree on whether or not the child can.
She's running the home alone, waiting for stability that never seems to come.
Or the children are going to stay in the United States or go to Brazil. That's the one issue that I think is putting pressure on this whole case. The parties can't agree to that. I mean, a court's going to have to make that decision.
Okay. And so, but you might be able to mediate the property and other
Yeah.
issues.
Correct.
Okay, fair enough. Well, what was the date in December that you identified as something that might work?
December 15th.
Yeah, the 15th, I believe, Judge. Let me check.
Okay, that is a Monday.
That is a Monday. That is correct.
So do we
That-
think this is a 2-day or a 3-day if it's the final?
I believe what I've been told by courts before is to set it for a day and a half when you have an interpreter.
Okay,
I don't have any response to that. I don't think there's enough issues to be longer than a day, but
okay. All right. And I guess Ms. Cormier, let me check back in with you because Mr. Russell's basically saying he doesn't see the need for a temporary orders hearing. He just wants it to be set for a final, and I think it sounds like he would rather that be sooner than later, but y'all have not completed discovery. So what's your response?
So with respect to a temporary orders hearing, we have no possession schedule in place. The parties are currently living in the same home with Mr. Thompson coming in and out, depending on his travel schedule. There's also, again, a financial dependency on Mr. Thompson. There is no court-ordered child support. It's just whatever is available to her, however she can order groceries, et cetera, et cetera. That's how they're operating. So we'd like to get some parameters in place. There is, for lack of a better word, there's I think what she would testify to the court at a temporary orders hearing is there is no downtime. There is no, hey, when will you be here? When will I have the kids? It's kind of I just have to be at the whim of another person's travel schedule. So having something in place, and we may or may not get reached in December. I've looked at the docket. There is a good chance we will get reached. But there are cases before us. And I agree with Mr. Russell, without having any orders in place, then we would be floating around until we can get back in. And with the holidays, that likely won't be until January.
Okay. All right. So based on what I have heard, I am inclined to do two things. I will change, I guess, your announcement from next week to a temporary orders hearing rather than the final. And you can reset the final to December 15th. Obviously, if you were able to work out some type of temporary orders, you could avoid that setting next week. If you could come up with an agreed order or Rule 11 on how things should work until that final hearing, that is solely up to the parties and their counsel. So I will grant the continuance and reset the final for December 15th. If you would just go ahead and call court admin to let them know, and Ms. Cormier, if you could prepare an order to that effect, send it to Mr. Russell for review as to the form. It can be emailed to Ms. Seeger for my signature.
Yes, Your Honor.
Judge, could I have one clarification? Is that temporary orders hearing? Are we going to discuss whether or not she's going to be able to move back to Brazil or not? Is that because that's kind of the main issue here.
Mr. Russell, I will represent to you that I understand that for the way I interpret the law is that's a final hearing issue.
Okay.
All right. Well, it'll be someone else next week, so I'll leave you to it. Best of luck to the parties and take care. You're free to go.
Thank you.
The judge finally rules. But what comes next leaves everyone uneasy. This case just got a whole lot deeper. If you enjoyed watching this intense courtroom moment, make sure to like the video, subscribe to the channel, and we'll see you in the next one.